Yes.
My lord, my ladies, we were looking
Just
at...
to say two things. We've read Jones. We think we would like to see the written submissions in front of the Employment Tribunal. It may well turn out that they are of no relevance, but we feel uncomfortable reading the judge's judgment without knowing how the submissions were framed. Realistically, obviously, we won't get them in time for anyone to make submissions on them. If there are points of substance in them which actually affect our decision as opposed to background, we will of course ask for further submissions in writing from the parties. I think that's unlikely to be the case, but we nevertheless think they will be useful background.
Perhaps, my lord, in that context, I can remind the court of the limitations on the parties before this court in respect of bundles and the size of bundles.
You can always ask for put more in.
My lord, I accept that and acknowledge that, but there is...
And there's an awful lot of stuff which is completely irrelevant, like all the stuff about how the administrative error in front of the EAT was all very regrettable. But why we had to have lots of submissions about it, which I haven't read, but they take up at least 50 pages, don't they?
My lord.
Okay.
We were looking at paragraph 124 of the EAT's judgment, and we were at 124D.
Yep.
And in respect of that, we had a discussion about the knowledge on the part of the claimant, and I referred to the fact that knowledge was not necessary, but it was a factor that was taken into account by the Employment Tribunal judge, and he was entitled, we say, to have regard to knowledge as he saw fit in reaching his conclusions as part of his wide discretion. I'm grateful that the court has read Jones, and may I just draw specific attention to the citation at paragraph 38 of Jones, to paragraph 19 from an EAT judgment in Barnes and Metropolitan Police Commissioner. Paragraph 38, where there's discussion about what it is that the tribunal is entitled to consider in respect of the claimant's prior knowledge. In that passage, His Honour Judge Richardson held, it follows that a tribunal will be entitled to ask questions about a claimant's prior knowledge. When did he first know or suspect that he had a valid claim for race discrimination? Was it reasonable for him not to know or suspect it earlier? If he did know or suspect that he had a valid claim, which we say means arguable claim for race discrimination prior to the time he presented his complaint, why did he not present his complaint earlier, etc.?
We got the point.
So we say that it's a much lower threshold that a tribunal judge is entitled to have in mind in relation to the factor of knowledge.
You presumably submit that 121, where there's the finding about the strategic not bringing in the claim, goes to that point.
My lady, precisely. Precisely. And of course, whilst we're touching on knowledge, and before I forget, there is a distinction to be drawn between a victimisation claim and a sex discrimination claim. So there cannot, of course, be any criticism of the tribunal judge's judgment in respect of the state of knowledge. If the claimant is a woman, she could have brought a sex discrimination claim if she was suspicious about being treated less favourably by HSBC because she is a woman.
So there's enough in the text to show that.
Absolutely, my lady, absolutely. Then just turning, please, in Core Bundle 121, the EAT's judgment to paragraph E in 124.
Yep.
There's reference to witnesses who no longer worked for the respondent was not entirely accurate. Well, there's reference certainly to one individual who had left the respondent, Mr. Zamy. The claimant had become aware of that on the 15th of July 2018. So that criticism, we say, by the EAT is simply of loose language, and it's hypercriticism that does not undermine the tribunal's judgment. At 124F, the EAT judge considers and states the judge didn't appear to take into consideration the fact that, contrary to his statement that the DSRs were responded to in a timely manner, significant and relevant information was missing from the data disclosed, etc. The judge did not appear to consider the manner in which the respondent disclosed information, etc. We say self-evidently that's wrong on the basis of the detailed reasons by the tribunal judge. He simply referred to the initial dates of the initial responses, but it is abundantly clear from the reasons that he knew well that there were documents missing from the DSAR responses that were then provided subsequently. That was the whole point being made by the claimant. And of course, we make that criticism that you'll have seen, that where the EAT judge says information was missing, that there seems to be criticism by the bank, in respect of the bank later, about the approach taken to disclosure, which we say is unfair in circumstances where there was no outstanding disclosure in the sense of any disclosure that had been ordered but had not been provided. And we deal with that at paragraph 69 of our skeleton.
But that's all rather elaborate. If there were a patently inadequate response to a DSAR, that would be relevant, even though it's nothing to do with litigation. If there had been evasive and partial responses to DSAR, that would be relevant to the exercise of the discrimination, wouldn't it?
Well, my lord, we definitely don't accept that there was any evasive response. But if there,
I'm just pointing about
yes.
You're making an elaborate distinction between DSAR and disclosure, in the sense of litigation disclosure.
Yes.
But inadequacy or any other vice in the answering of the DSAR would be capable of feeding into a discretion, in principle.
In principle, and what we say is the judge, the Employment Tribunal judge, obviously did take it into account. And what the EAT judge was here doing was impermissibly considering what weight she would have put on those factors in respect of the later documents, rather than, and as she ought to have done, we submit, not interfering with the weight that the tribunal judge put on those factors. And at 124G, reference to the judge did not consider the point made in Appellant and the impact of the claimant's knowledge of the further information which had not previously been sent to her. It's, we say, absolutely clear from the judgment, including by references to Appellant and the claimant's state of knowledge, that he absolutely did do so. And of course, Appellant is, of course, an illustration of the importance of giving due deference to the tribunal's exercise of its discretion. Yeah. This court will remember that the tribunal in that case decided to extend time in respect of complaints made 9 years later, and the EAT and Court of Appeal, with doubts, nonetheless declined to interfere in that discretion exercised by the Employment Tribunal, rightly because of the due deference to be paid to tribunal judgments. Paragraph 124H, there's criticism of the judge did not engage with how and when the claimant's personal circumstances referred to in paragraph 126 impacted upon her, and particularly upon her after she'd obtained the additional information. That is an unfair criticism made of the Employment Tribunal's judgment, not least where the judge does specifically refer to the claimant's explanations at paragraph 72 of his judgment, and again at 126. And even on the claimant's own case, those explanations did not impact the period prior to June 2020 or after August 2020. Yet the judge appears to consider that these circumstances should have led to the tribunal judge granting the extension, which is, of course, the wrong approach and entirely impermissible. What she would have found, I respectfully submit, was not the right question. The right question, of course, was whether or not the tribunal judge was entitled to find as he did. At paragraph 125, the tribunal judge makes criticism about the Hogan test, which the claimant had undertaken, and about not having been progressed through the GCAS system in circumstances where she said merited much greater caution. The judge had not heard evidence from Mr. Lacour. But of course, the judge had heard evidence from Lauren Collette, a senior individual in HR at the respondent, who gave evidence, was cross-examined, was asked questions by the tribunal judge on precisely this point. He was entitled and obliged to make findings. Well, I don't need to go that far. He was entitled to make findings in relation to this issue without having heard evidence from Mr. Lacour. And the EAT judge is unfairly critical where he notes this both here and at paragraph 29, 44 of her judgment in this regard. We make some other criticisms of the EAT's judgment in our skeleton argument. For example, at paragraph 57, core bundle 33. And for the court's reference, at 1152 and 16, so let me take the court to 1152 of the EAT judgment. That is on page 115. The tribunal, there's a criticism that the tribunal did not make an impermissible decision in respect to the first claim to decide to proceed to hear evidence of the OPH, but then goes on notwithstanding the inherent risks, etc. And so although the judge, EAT judge, seems to be saying it was fine to go ahead, the fact that there's commentary on it suggests, when one reads the judgment as a whole, that the judge was concerned about the listing of the OPH and the time limit issue, even though it was a different judge who had listed the preliminary hearing and an order in respect of which there was no appeal. And we say that that impermissibly infected the rest of the EAT's judgment. And then we say at paragraph 29, which I referred to, the reference to no evidence from Mr. Lacour, core bundle page 75.
You're running very short of time. Are you choosing your best look at the points you most want to make? You may only have room for one more point.
My Lord, it's those criticisms that we make of the skeleton, in the skeleton at paragraph 60b for the court's reference. And also, I ought to make the point that where the EAT judge is critical of the judge's criticisms of the claimant, so for example, at paragraph 43, core bundle page 82, that was plainly the EAT judge stepping into an arena that she was not entitled to step into, in the sense that there was no appeal in respect of the criticisms being made of the claimant, and the judge had heard evidence, seen material, watched the claimant be cross-examined, read the Barclays statement, read her own statement. He was absolutely entitled to criticise the claimant, insofar as he did, about her contrived approach. And so that this court is clear, the EAT judge is critical of the claimant, of the tribunal judge referring to the claimant as pushy and indefatigable, but that has to be set in the context that pushy is in quotation marks because it arises from positive feedback made about the claimant that she relied on. So that is, again, an unfair criticism being made of the tribunal judge.
I think for the rest, you'll have to rely on posterity.
My Lord, yes. So in respect of these grounds 2, 3 and 5, which is all about the just and equitable extension, we say applying the principles of law in terms of what the tribunal's approach should be, the judge was absolutely right in his approach, and the EAT judge impermissibly sought to go to approach contrary to the principles that we've outlined in overturning the just and equitable
We have that
discretion
point.
decision, and did so both in relation to the judge's decision on sex discrimination and also in respect of the victimisation claim.
Yes.
So for all of those reasons, we say that the appeal should be allowed and the judgment of the tribunal restored.
Thank you very much
I'm
indeed.
very grateful.
Have my ladies have any?
Oh, thank you.
Right. Yes, thank you. Mr. Siegel.
Ladies and Lord, afternoon. I intend to address the time point first.
Yeah.
Section 123 1 of the Equality Act is set out in various places. It's, for instance, in Core Bundle, page 95 at paragraph 70.
Do you really need us to go to it? You're
I
making-
think it is
Yeah, fine.
just to have
I'm
it
not
in
stopping
front
you.
of
I just wondered whether you.
It might.
Where do you want to go then? Call.
So I've suggested page 95 within
Yeah,
the EAT judgment at paragraph 72.
Whoever's doing the authorities bundle, they might in future think that the key statutory provisions ought to be in it.
I think there's an unreasonable fear that I've detected recently that the 10 authorities that are supposed to be our benchmark include the statutory provisions, which I don't think is right. But I think that might have governed the.
And it's only a bench. We are very persuadable.
I shall
To
quote
see
you.
further authorities where relevant.
I
You will have seen many cases in which we've had bundles and bundles of authorities, none of which are referred to. Indeed, we're not really referred to many of these. Though to be fair, some of the ones we would have had to have read.
So,
anyway.
when a tribunal considers pursuant to 123 whether it's just and equitable to identify, and this is subsection 1b, such other period for limitation purposes other than the default 3 months, there are two largely separate aspects which tend to arise. The first, which applies in the majority of cases, is a critical examination of the period between the date on which the claimant had the necessary knowledge to bring the claim and the date on which they, ex hypothesi after 3 months, actually issued the claim. And at least sort of this court will be very familiar with decisions of that sort, examining the length of delay, the reasons for the delay, and the claimant's understanding of their rights and of the applicable time limits, issues like that. The second aspect, which applies only in a minority of cases, not rare, but it's in a minority of cases, including this one and Appellant, is the need to establish the point in time at which the claimant had the necessary knowledge to bring their claim and whether, if it's relevant, any delay was their fault in acquiring that knowledge. And in practice, a case tends to fall within either one or the other. That's to say, if the claimant discovers critical new information sometime after the primary time period has elapsed, later than the date of the act to which the complaint relates, that's why I wanted you to have this in front of you, that sets the time running. Then,
But hang on. Let's set the time running in any formal sense. What you saying sets the time running?
123(1)(a),
Yeah.
the claim must be brought within the period of 3 months, starting with the date of the act to which the complaint relates.
Oh, I
So-
see. Well, that's obviously right. I'm so sorry. I thought you were saying that the date of knowledge sets
No,
the
no,
time
no.
running.
That's the whole point I'm making, is that the time limit starts from the act. If you have an act which seems entirely benign, but 9 years later transpires to be unlawful, your time period starts, and that's the distinction to some extent between the way in which personal injury claims are sometimes analysed and employment claims are sometimes analysed. The time starts from the act, whatever you knew about it. Then you ask yourself, well, what did you know about it in order to decide whether it's just and equitable to ascribe such other period?
Yeah.
Now, as I say, if a claimant discovers late in the process that what might have been a benign act was a potentially unlawful act, they tend to bring their claim very quickly thereafter. So, as I say, either one aspect or the other tends to apply, not generally both. And of course, in either category of cases, issues relating to the relative prejudice to the parties, if one extends time, might be relevant. But importantly, and this is the first point I want to make, different legal principles apply in reviewing on appeal a tribunal's decision in those two categories, and also different factual considerations apply in the two different categories of case. What do I mean? As to legal principles, the respondent makes much of the breadth of an employment judge's discretion under section 123. However, and my lord pointed this out in argument, that broad discretion is primarily applicable, these are my words, not my lord's words, but primarily applicable to evaluating what are normally either obvious or agreed facts in that first, more common category of case. So a typical time point hearing lasts very little time at all. Sometimes the claimant gives a bit of evidence, sometimes they don't. Everyone knows when the act happened, and it's assumed that the claimant knew about the act and it was potentially unlawful. Everyone knows when the claim was put in. There may be some evidence about the claimant having been ill or ignorant or her lawyers messing up or whatever it might be. And then a decision is made as an exercise of discretion. However, in the present category of case, the primary task of the tribunal is one of fact-finding and analysis, and that's the point that I apprehended my lord was making in argument. A determination whether a claimant has the requisite information to bring a claim under the Act is a mixed question of fact and law. It's not the exercise of a discretion. And as such, it is susceptible to review if the tribunal does not take relevant matters into account, takes irrelevant matters into account, misunderstands the law, or misanalyses the facts in light of the relevant law. Both parties relied on the judgment of Lord Justice Leggett in this course in the Morgan case. It begins in your authorities bundle at page 86. I'm only going to take you, I think, to two authorities. This is the first. And if you go first to page 89 of the authorities bundle, within that judgment of Lord Justice Leggett, you get there, look at paragraph 5. It's notable in passing that the previous procedural history in that case, which is summarised by Lord Justice Leggett at that point, the Employment Appeals Tribunal also found that in exercising its discretion to extend time under section 123, the Employment Tribunal had failed to consider each claim separately, had not identified or taken into account the reasons why the claimant had failed to bring each claim in time sooner than she did, and had taken into account an erroneous perception of the strength of the reasonable adjustments claim. Accordingly, the question whether it was just and equitable to extend time was remitted for reconsideration, and then at paragraph 6, the matters remitted were reconsidered. No new evidence, note. The Employment Tribunal found the claim based on a failure to make adjustments was well-founded, and it was just and equitable to extend time for bringing that claim and also the claim of harassment. That's just an unremarkable example of an appellate court upholding an appeal from a determination under section 123 by reason of the Employment Tribunal not taking the proper matters into account. And in fact, in that case, the tribunal reversing the original decision without receiving any new evidence. And then the paragraph that is cited in both of our written skeletons at A93, paragraph 20, where Lord Justice Leggett elucidates the distinction between, on the one hand, the difficulty in challenging a pure exercise of discretion, and then just above G, the requirement in these circumstances to disturb the tribunal's decision if the tribunal has erred in principle, for example, by having regard to a factor which is plainly irrelevant significant, or by giving significant weight to a factor which is plainly irrelevant. In the latter context, while the appellate courts, my learned friend is right to say, are reminded not to subject a tribunal decision to overly minute examination. It is in this case equally important to bear in mind some very often quoted words of Lord Justice Sedley, the second authority I'm to take you to in this context, which is Anya. The report begins at page 2 of your authorities bundle. And may I just note along the way Lord Justice Sedley's reliance on the famous judgments of both Lord Justice Mummery and King and Lord Brown Wilkinson and Zafar. For instance, if you go to page 10 of the authorities bundle, excuse me, between E and F, claims of race and sex discrimination present special problems of proof for complainants, since those who discriminate on grounds of race or gender do not in general advertise their prejudices. And then at page 14, at E, that where there have been discriminatory factors influencing the decision complained of, it will in general be only from the surrounding circumstances and the previous history, not from the act of discrimination itself, that they will emerge. So just pausing there, in a case like this, it is critical to understand whether important surrounding circumstances only came to light at a time much later than the act. And then the passage that I had initially alluded to, page 16, paragraph 20.
So where was the surrounding circumstances passage? I'm very familiar with this case, but
Sorry,
load
it
it
was
up.
at page 14, my lord, towards the bottom of paragraph 21 at E. It's halfway,
yes, thank you. Okay, now you're taking us to 16.
and to page 16, yes, and to, this is the most, I believe, the most famous part of this particular judgment in relation to the job of an appeal court in any event, the second half of paragraph 26, but I'll read it from the second line. The courts have repeatedly told appellants that it is not acceptable to comb through a set of reasons for hints of error, fragments of mistake, and try to assemble these into a case for oversetting the decision. No more is it acceptable to comb through a patently deficient decision for signs of the missing elements, to try to amplify these by arguments into an adequate set of reasons, just as the courts will not interfere with a decision, whatever its incidental flaws, which has covered the correct ground and answered the right questions. So they should not uphold a decision which has failed in this basic task, whatever its other virtues. That is this case.
Well, is this what are you saying are the failures to ask the right questions?
This case
Isn't, I mean, what can I put to you? What's worrying me? It looks as though the judge came to conclusions on a series of clearly material points relevant to the exercise of a discretion of this sort, including what she knew when, but he expressed them in incredibly summary form, so you can't see the details of his working. So it's a classic Meek type deficiency, if it was sufficiently deficient. I haven't spotted in any of the things that Judge Tucker said that he failed to answer the right, or indeed in my own looking at the judge, but he failed to ask the right questions. You'll, I'm just, no need to answer that straight away, but that's my concern.
Well, can I give two short answers, but I hope the validity of them will become clearer as I
Yes.
have my submissions. But the short answers are, he did ask himself the right questions by and large, but he did not cover the correct ground. It's that part of it that I had in mind when I said that is this case. And it's not quite right to say of this judge that he simply states a bald conclusion and we're all left to guess what he had in mind, which would be bad enough, as my lord points out, from a neat perspective. He does actually make, albeit pretty short and at times opaque, reference to what he is relying on in reaching those judgments, and more can pretty readily be inferred from what he recites in the rest of his reasons. And on either basis, what he says and what can be inferred, he's taking the irrelevant stuff into account and even more egregiously leaving the most relevant stuff out of account. So I don't accept, I'm not suggesting that my lord has put it in quite these extreme terms, but I wouldn't accept that in this case, the judge has asked the right question, answered it, and we just have no idea why. We do actually know why, and it's the wrong ground that he had covered in getting to those answers. And even at the permission hearing for the Employment Appeal Tribunal appeal, it was clear to Mr. Justice the President, both that the issue under section 123 in this case was whether the judge had taken proper account of the relevant facts, and that there appeared to be an apparent failure to do it just on the face of his decision. Can I take you to the supplementary bundle, page 154?
Give me one moment.
Of course. Going to be looking, when you get at paragraphs 35 to 37, 35 begins with submissions, as it were, and then continues in that and then the following paragraph with the judge's reasoning. I pick it up 3 lines into paragraph 35. As Ms. Banton, who was then representing the claimant, points out, in order to succeed in a claim of victimisation, a claimant needs to be able to show that one of the acts, the protected acts, has influenced the alleged victimiser. It was the claimant's case, it was only in late August 2020 that she discovered the circumstances of why she was not hired in 2018 by the respondent. In particular, it was her case that it was only after the direct intervention of Mr. Barrett that she was not hired. Until August 2020, she knew nothing of and did not suspect Mr. Barrett's role in halting her employment. It was only on the 27th of August that she discovered he was fully cognizant of her earlier claims against Barclays and had interfered in a negative and substantive way in the hiring process. Indeed, it wasn't until 17th of October that she learned what Mr. Barrett had said about her that had halted her employment. Now, so far, that is entirely uncontroversial. It has never been suggested, nor could it be, that she knew any of those matters before the dates they are identified. It is said that the piecemeal drip feed of disclosure, and by disclosure there is meant responses to the DSARs, on the part of the respondent had operated to delay her from obtaining evidence in the salient fact. That's also uncontroversially true. Whether it was culpable, negligent, or innocent is another question, but that it happened is not an issue. The tribunal had erroneously found that her DSARs were responded to within 6 weeks, but in fact, as the respondent accepted, some of the material emails later disclosed had not been located in the original search. It's the claimant's case that the cause de facto in the delay fell on the part of the respondent and not her, and she should not be penalised for it, nor the respondent profit from it. And again, uncontroversial. The President isn't there saying that the claimant has submitted, still less that the President has found that the respondent did anything malicious in this regard. But the claimant asked at the right time for the right documents. The respondent had the documents, and for whatever reason, only gave them to her 2 years later. This ground of appeal, I continue, goes to the question whether the tribunal erred in its approach to the exercise of its discretion. Erred in its approach. What is plainly understood to be a relevant factor, that is the fact that the claimant had in late 2018 brought claims for post-termination victimisation against Barclays, which arose out of the same facts as the case brought against the respondent, I mean, that's, I would respectfully suggest, quite only if you read out of the same facts very widely indeed, including the understanding, as the tribunal has described it, that this would mean that she had sufficient knowledge of the facts which would provide her with her grounds of complaint of victimisation against the respondent. Whilst, however, it may be.
So we have in a long passage like this. It's easier just to let us to read it, and I have read it, as I'm sure my ladies have as well.
Well, I'm grateful if you're content to have read through to the end of paragraph 37. I will.
Oh, I did well. I know, but my observation is a fortiori. We will now read to the end of 37.
Thank you.
Yes.
On more detailed consideration at the full appeal hearing, of course, that was the view taken by the judge. Same view. And I said earlier that the two categories of case, the one where the claimant knows and just doesn't act within 3 months, the other where the claimant says she did not know, might engage not only different legal principles but also different factual considerations. This case presents a paradigm illustration of that, which neatly demonstrates, we say, where the judge fell into error. Where the necessary ingredients of a claim are known to a prospective claimant who delays in bringing their claim, it is often relevant to consider what their understanding of their legal rights was, whether they were an articulate and intelligent and knowledgeable person. Had they brought previous claims? Did they understand the applicable time limits? Such a claimant will be viewed less sympathetically than one who is naive or ignorant. But precisely the opposite consideration ought to apply where a tribunal is deciding at what point in time a claimant knew or suspected that she had a decent discrimination or victimisation claim. At what point in time she had the necessary knowledge of the ingredients of such claims. In this case, you've read, the judge makes great play of the claimant having brought a previous claim against Barclays in 2018, her knowledge of the DSAR process and use of it, and her willingness to litigate where she considered she was the victim of unlawful treatment. Indeed, my subjective view, at times when I was reading the decision, that seemed almost to be, at least at a psychological level, the main basis for his decision. But consider, on the critical question of whether the claimant knew in July or August of 2018 that she might have a claim of victimisation or discrimination against the respondent, not Barclays, all that evidence about how well-informed, I'll use as a shorthand, how litigious the claimant was, should have been assessed as strongly supporting her case that she did not have the requisite knowledge at the time. Put it another way, can it seriously be suggested of this claimant that had she had any real suspicion before August 2020 that HSBC's decision not to offer her the job she so desperately wanted at that time, in 2018, was an act of discrimination or victimisation, that she would not have issued such a claim at that time?
Well, the judge obviously thought it would, and he said that she found as a fact that she made a strategic decision not to pursue a claim because she hoped to be able to secure employment with them in the future.
Well, apart from the fact that that doesn't square with what his understanding of what happened later in the process, later chronologically in the process, where the claimant has brought a claim as soon as she finds out about this, but then continues.
Well, that's not necessarily inconsistent because we're now in. She didn't bring the claim until late 2020.
No, I'm saying that thereafter the claimant's case was she was still meeting with representatives of the bank in the hope of securing a job.
We can't get involved in factual challenges of that sort, that is what the judge found. What you were saying, quite apart from the point you just made, what was the point you were about to make?
Well, my lord, all right, let me start by putting it at its lowest, which it seems to me must be uncontroversial. The claimant's litigious nature, if that's the way the judge would characterise it, her knowledge of time limits, her understanding of the law, her understanding of the DSAR process, none of that can count against her in determining whether she had...
But he doesn't attempt to count. He doesn't mention any of those things in this part of his reasoning at all.
Well, do you mean at paragraphs 121 to 123 of his
Yeah.
reasons? Well, I'll come on to this, but he, as my lord has pointed out, and this can scarcely be used against me, he doesn't say anything particularly much in those paragraphs. You have to some extent to understand what's in his mind by going through the other 120 odd paragraphs of his reasons. And he certainly goes to town in relation to that aspect of the case, her litigious nature.
I
Let's
think
use
he's
as a
just
shorthand.
making a conventional point, which is not surprising to find an employment judge making, that she can't run the argument, I don't know about time limits.
Well, I think that's a very generous reading of his judgment, since that wasn't an argument she'd ever raised.
But we're supposed to read the judgments generously, aren't we? Not nitpick.
No, I'm not suggesting you're reading it generously in the sense of not nitpicking. I would suggest that a fair reading of that judgment means you finding that the employment judge held against the claimant in respect of his decision that she was well versed in the requisite legal provisions. But I can't make it any better than I have. The fact, however, that had the judge taken, well, we say that was a fair inference for the judge to have made, that she would have been much more likely, given the person she was and the experience she had, to have brought a claim at that time if she had thought she had a claim to bring.
Not asking us to go behind his finding of fact. And then you're straight up against Volpe and all that line.
You mean the finding of fact that it was a
Tactful.
strategic...
Yeah.
You were saying we should infer something that's entirely contrary to a finding of fact that the judge made.
Well, my lady, I take the point. Maybe I just put it in this way then. And I think potentially there's no potential disagreement about this. Those matters were not matters which could possibly count against the claimant in relation to the determination that we're
Which
discussing at the
matters?
moment.
Which matters? Sorry.
The
Her
personality of the claimant in being litigious.
Sorry,
and,
you're dropping your voice.
the
which
claimant
matter
having a
couldn't pos-
full understanding of her legal rights and the time limits.
There's two different things, aren't there? One as you say, is her understanding, which you're saying, aha, would have made her know she needed to get on with it, but also might have been the reasons my lord pointed out. And then the other issue is the finding of fact.
Yes, my lady, and I'm acceding.
And they're different.
I agree, and I'm acceding to the proposition that if you take that finding of fact, as you describe it, and
But what would you describe it as?
well,
What would you describe it as other than as a finding of fact?
well, lady, I promise you I'm not being flippant, but it seems to me equally possible to describe it as a conclusion, a piece of analysis, as it were, based on his factual findings, as opposed to a finding of fact. He doesn't say that there was any evidence, either from the claimant or anyone else, that it was a strategic decision. He doesn't refer to the
Well, that's
answers
slipping
she-
into a different point. I must say I agree with my lady. This is clearly a finding of fact about what her intentions were, which, as we've been told ever since the 19th century, is much a matter of fact as the state of the digestion.
Indeed.
So this is a finding of fact. You are entitled to make the point, and I'm very alive to it. Look, we're not told on the basis of what evidence he reached that conclusion. Although, quite the other way, he did clearly hear her cross-examined about the time point, and a reasonable inference is that this is the conclusion he reached having heard that cross-examination.
My lord, I entirely accept that, and I hope I wasn't being overly nuanced in responding to my lady's point. But all such conclusions can be challenged, have been successfully challenged, including in one or two of the cases I've already taken you to, where the conclusion, and this is why I say it is a conclusion of fact as opposed to a finding of primary fact, is based on the taking into account of irrelevant matters or the taking into account, sorry, I beg your pardon, or the failure to take into account relevant matters. So yes, I accept, strictly speaking, the state of a man's digestion is a fact. But if you find that a man had a poor state of digestion because he had eaten a curry he did not in fact eat, the primary fact, or that he had not taken the indigestion tablets that he should have taken when in fact he had, that finding of fact cannot stand. It's not perverse, it's just having taken into account irrelevant information.
Well, I think probably we need to argue about labels. If it is reached on a basis which the undisputed primary facts don't support, then it is perverse. But you can equally well say perhaps that he failed to take into account those undisputed findings of primary fact. I don't mean to worry too much about labels, but at the moment
you say is clearly based on the preceding material in paragraph 121, i.e. fully aware of elements of a claim from unemployment
Exactly.
in July 2018, accused about a tax type, preceded claims against Barclays, strategically opted. So that conclusion is based on the antecedent reasoning that she knew very well she had an element in July 2018.
Exactly. And when I come to
well, can I just, in case you think my lady, my lord, necessary is to read it, my lady and me necessarily read it the same way. I don't think that is that a safe assumption. It's certainly it's the following sentence. But if there was that we know he was interested in, we know there was other evidence that appeared to show her still interested in a job with HSBC in 2019 and 2020. So it's not just an inference from the fact that she knew, as he found, all the elements of her claim and yet chose not to pursue it.
He's reaching an inferential conclusion based on some irrelevant material, a completely
Well, I think, could we at this point, we got into this from you referring to authorities and referring to those well-known passages in Anya, but I think it'd be good now to get down to specifics. Yeah.
The essential chronology in this case was not at all complicated. The judge found the relevant recruitment process began in May 2018 and ended by the end of July 2018. Early in that process, on the 18th of May, the claimant volunteered to Mr. Tree, the hiring manager, that she was in dispute with Barclays. She didn't tell them that she had an outstanding claim, nor, critically from the perspective of victimisation, as this court has identified, what the dispute was about, that there had been no
Can we just pause there? Do we know she didn't, or is there just no finding that she did? She did tell them about the dispute.
Well, she says, I told them I was in dispute, and I assume...
That's the judge... do we know what she said?
Well, that's what the judge recalled. And
it's left open what she told them about the dispute.
Well,
I'm sorry, I'm not trying to make difficulties. I'm just trying to be precise, because the problem here is that there are a lot of unanswered questions.
well, there are, and as Anya reminds us, there's only so far you can go to try and rescue a decision. HSBC has been represented throughout by the most experienced legal team. If it had been an issue whether the claimant had referred to her dispute as being a legal claim
Yeah.
for discrimination,
Yeah.
is there anyone in this court who doesn't think she would have been cross-examined to that effect? Is there anyone in this court who thinks if she'd answered yes, that wouldn't have found its way
No,
into
no, that's a
the
perfectly fair
closing
point.
submissions? Yeah.
But nevertheless, I think the actual finding is that she told them she was in dispute with Barclays. There is no finding that she told them what the nature of the dispute was or whether it was litigious.
Correct.
Yeah.
Still less, and this is an important chronological point that has been completely misunderstood by the judge, and because the respondent is trying to uphold his judgment by the respondent, there was no reason at that point in time, or for some weeks after, for believing that Mr. Dutree might have had any concern on that point. But it might have contributed to the decision not to hire her, because as you're about to see, what happens in this process is two potentially negative things happen in May. That was one of them. The other is the so-called bad reference. Then, instead of the hiring process being interrupted at that time or going cold, the exact opposite happens. Mr. Dutree and the other hiring managers solicit and obtain a whole series of excellent references, including from Barclays indirectly, put the claimant to the relevant test or tests that someone on their way to being appointed needs to take. So again, early on in the process, again in May, Mr. Dutree told the claimant that the respondent had received a negative reference from Barclays. And we know, roughly speaking, what that reference was. It was nothing to do with she'd brought a claim against Mr. Fares or Barclays. It was that she was a bad employee. I mean, impossible, I think.
You're probably right about that. I wasn't clear what the nature of the bad reference was, but I probably missed it. Where's the finding about what the bad reference was?
So you want it in the
I want it
Employment
in
Tribunal judgment?
Yes.
Forgive me. Perhaps unsurprisingly, he said with asperity, it's at paragraph 44 where you would expect to find any detail of it. There isn't any. However,
both sides have this problem, but I had always just been told that there was negative feedback, stroke a bad reference. You were saying, as if it was common ground, that we know roughly what the nature of that was.
I can't remember where it
There
is,
are
but
documents.
I can sort of see it in my head.
there are
It's broken
contemporaneous documents.
broken
that-
sentences in
that-
italics.
Yeah, there are contemporaneous documents that later come to light. But I
Yes, sir.
agree, the direct answer to your question, my lord, which is where in the judgment.
Well,
is the
I will be less austere. Where do we find elsewhere in the papers what the nature of the
Can I
original
take
negative
you to
feedback
that
is?
in the natural course of submissions? Because
Yes, of course. I'll keep quiet. Okay, so
no, please don't keep quiet. Just because it will flow more naturally if we.
No,
if
that's
we
fine.
Take the chronology as it was. And of course, my learned friend has her reply, and if there's anything in any of the papers that suggests that it was part of that bad reference, that she was.
no, I didn't think it necessarily was. I just wanted factually to know what we knew about the bad reference.
Okay, I will take.
And you'll take that later. Keep going.
So again, assuming I'm right, my lord, as to what the content of that reference was, there was no suggestion that Barclays at that time had referred to her claim against them. And again, as events unfolded, there was no reason for the claimant to believe that that negative reference would cause the respondent not to appoint her. As you're about to see when we look at contemporaneous documents, the opposite happened.
Yeah.
And we say that that critical chronological fact was completely misunderstood by the judge. The initial so-called reference about which Mr. Dutree told the claimant in May seems not to have significantly prejudiced.
So just show us where he misunderstands about it.
Well, it's the entirety of the bit that my lord correctly identified as the heart of his judgment. 121, 122, 123. He is referring there, because he can only be referring there because the claimant didn't know about the Mr. Barrett reference in 2018. He is referring there to the reference that she knew about. He keeps saying she knew about this reference from Barclays in 2018. Yes, she did. She knew about reference 1, which was...
Well, is that right? Is that right? What about what she was told by Ms. Assag in the texts?
I'll come to that later, but can I...
Well, all right,
well, my lord, all
but
right.
you're assuming that the judge here was referring to the anodyne bad reference, anodyne in the sense of not giving her any cause for complaint.
Yep.
I don't know whether he was referring to that. If he had heard evidence, and it appears he did, about her having been told about other reasons why she hadn't been appointed, that's not anodyne at all, and she would have known all the elements of her claim, except possibly what the nature of the litigation was. We just don't know.
We do, actually.
Okay,
Even on
good.
the judge's judgment. If you go to paragraph 44, and I will take you, of course, to the new argument of the respondent by reference to particulars of claim, paragraphs 51 to 54. I will do that. But just to answer my lord's question, what is the judge referring to?
Mm-hmm.
We have already discovered he doesn't say what the negative feedback was, but he does say that the content of it was not inconsistent with her knowledge and understanding that she had when her appointment was not progressed. By email dated 5th of July, the claimant provided positive reference to seek to address the negative feedback or observation. So he is right there to identify that the first reference, and you'll see all this when you look at the contemporaneous document, that the first reference, which was actually in June of 2018, preceded all these other matters, including any texts exchanged between the director at HSBC and the claimant, and of course preceding Mr. Barrett's intervention. And so if my lord is asking me, is there any basis for reading paragraph 121 to 123 when he refers to the bad reference from Barclays as referring to anything other than what the only thing he talks about in almost identical language at paragraph 44? No, there is not. When you add to that, because I saw that you were all troubled by this, I will take you to the passages and give you my analysis of them. But when you add to that the respondent did not rely in its submissions on the texts exchanged between the director and the claimant, that the judge makes no reference to them, unsurprisingly, that the respondent didn't rely in front of them in the EAT, and the respondent didn't rely on them in front of you in their lengthy written skeleton.
Sorry, I just want to make sure I've understood your point, which I don't think I understood, and I think it was my lady's point as well. The key phrase in 121 is due to bad reference from Barclays. So when he was fully aware of the elements of her claim, he's basically saying the bad reference from Barclays gave her all she needed for her claim.
That's what he's saying, and that's
Yes, I
where
see
he
it.
errs.
Yeah, I'm just not as quick as the rest of you.
No, that's certainly not true, my lord.
No, I'm not being clever. Sometimes one just needs to read these passages again and again to see what they're saying and not saying. Right, sorry, you were on to a
But it
different
wasn't
point.
to-
You were saying the point, you're now coming to the text changes, and you're saying that point wasn't made below.
Well, I will come to it, but I was addressing the point my lord made to me, which was, how do we know that at paragraphs 121 to 123, the judge may not have had those text exchanges in mind?
Yes, well, I
By
was
giving
moved.
two answers.
Right.
One, we know what he did have in mind, see paragraph 44. Two, it is inconceivable that he would have had those texts in his mind, given that A, most importantly, he never mentions them, but B, the respondent never relied on them. Indeed, didn't rely on them until this morning.
Well, hang on. I get your first 2 points. Hang on 1 second.
I thought they cross-examined on them.
Well, I wasn't there.
Neither was I.
And
That's why
no, so all I can say is, if my learned friend says she cross-examined the claimant by reference to those texts, which is, I think, the language she used, of course we accept that happened. But I can be sure of one thing. If my learned friend asked the sort of questions that you are imagining she might have asked, and we don't know if she did yet, she certainly didn't get the answers she wanted. Because if she had, then when she came to construct a very long then it was respondent's chronology, setting out all the important events, including during the period June and July and August and September of 2018, no reference was made to the text. And when she came to write lengthy written submissions and then I think additional submissions, no reference was made or reliance
So which submissions are we talking about?
The submissions of my learned friend in front of the judge.
Well, we haven't got those yet.
No, but you asked my learned friend.
No, I know we did. I know we, and you have got them and you've read
I'm
them.
saying that
I
I
see. Right. Okay.
anticipated
Sorry.
the court's interest
Yes.
and
good.
therefore asked during the morning session, got the answer, and I've got them on screen, no, and then to double check, ask my learned friends before we adjourned, I'm going to tell the court this afternoon that you made no reference to them in your submissions. Can you just check I'm not going to be misleading them? And I haven't been told otherwise. So yes, if you want them, we will send them
Well,
to
we
you,
better
of
have
course.
them, but okay, so right.
But it will be
sorry,
by
you were saying it in such
omission
an
in
elliptical
this
way, I
regard.
didn't follow. You have looked at the submissions
Correct.
because they're available to you, and they were not relied on in front of the judge.
Yes, I haven't
Okay,
read
well,
them
that's right.
through,
That's say the
but
texts or any answers obtained in cross-examination about the texts were not relied on before the
Correct.
judge. Okay, well, that's very interesting. Thank you.
oh yes, I'm reminded that in fact on this one occasion, though helpfully for me, I didn't give the judge enough credit because the judge does cite, albeit by reference at paragraph 27 of his judgment, to an earlier statement that the claimant had made, that the gist of the negative reference in June was, and I'm reading from about just under
thank you.
halfway down, that she had been a total disaster. You see that, it's quite small print. But certainly nothing, and you can imagine if anybody might have stretched it to include such an implication, the claimant would have done, nothing about any claim or protected act. So I say paragraph 44 should be read with that when interpreting paragraphs 121 to 123. Though there will come a point, probably more than one, at which I will be suggesting to you that the time for interpretation has to be over and the time for remission has to begin. So what happened, picking up...
Sorry to interrupt, can I just ask one further little question, please, while it's in my mind? Did the respondent rely on the texts in its responses to the appeal to the Employment Appeals Tribunal?
I'm told no, I wasn't there. Again,
I think that's right.
and nor in the 25-page skeleton that was presented to you. And there are good reasons for that. Obviously, a litigant is entitled to say, sorry, I missed my best point at the Employment Tribunal, the Employment Appeals Tribunal, and most of this case, but now I found it, I should be allowed to make it. I'm not taking a procedural point here. It's a, let's be blunt, partly a jury point. It was obviously not a good point if someone like Ms. Gupta didn't spot it, but also when we look at it, we'll see it obviously isn't a good point.
Okay, well, you're going to do that.
But we will see that. But I want to continue the chronology. So what happens, and we'll see the contemporary stuff, sorry, I keep saying that, what happens after the bad reference is everything seems to go better, more and more favourably. And indeed, what the claimant then obtains in August 2020, or sorry, what she sees for the first time in August 2020, are the documents that begin at 164. So now can I take you to the
Yes.
contemporaneous documents of supplementary bundle?
Yes.
So,
Sorry, just tell me that again. In August
so in August of 2020, the claimant for the first time sees the response to her first 2020 DSAR. The response was made at page 164 in June, on the 17th of June. The claimant explains that she was going through a certain personal hell for the following weeks and therefore didn't read it until August. But we accept the response was made in June. Note the first paragraphs of page 164, in particular the second. Please accept our apologies that some of the emails attached were not located in your original search.
where are we?
Sorry, my lady, it's page 164 of the supplemental bundle.
Sorry, I was looking at the chronology.
So picking it up in the middle of 165, an email string that as always runs backwards, Mr. Zaimi writes to Mr. Detreat, please interview her. And Mr. Detreat replies, we need...
Sorry, 16. Where
165.
do I find please interview her? Being stupid.
Just above the second hole punch. 165 supplementary bundle.
Oh, yeah, sorry. Afternoon, my eyes are going fuzzy. Yeah.
Yeah. Then above that, the reply from Detreat, we need to hire her. The reply from Zaimi, do it.
Yeah.
And then we have, and I don't think this is dated next, whatever it is, teletext exchange or something. I hope all's well. Want to know if you give me some feedback. We're looking to hire. Yes, Carmen said she'd given me as a reference. Known her a long time. Recently at Barclays. So presumably this
So
is
sorry again. I mean, so we're looking at 166.
Yep.
Did you tell us the date?
No, I
said
said
you
that
don't
I
know the
don't know
date.
the date. So it could, this is the one document that could either be before or after the bad reference. I don't know.
But,
Well, we see the bottom email is the 11th of June.
It is, but what I don't know, I mean, it may be an inference that it's before the 11th of June. I just don't know.
but sorry, but the top bit is what? It's not an email. It's a series of timed. Is it texts? SMSs?
I don't know. It was between two people at the respondent, or at least, sorry, I
One
don't
of them
know
appears to
that.
be-
Between one person at the respondent and someone who was either at the respondent or still at Barclays, but who had known the claimant at Barclays.
Let me just read through it. Or is this a typescript of a telephone conversation? No.
No, because of the gaps of the timing. This is some sort of instant messenger.
Yes, it must be. My lady's more techie than I am.
It's
Some kind of instant
Bloomberg chat
Sorry?
on the 11th of June.
A what chat?
It was indexed by the respondent at
Yeah.
an earlier stage as Bloomberg
All right.
chat,
Okay.
11th of June.
Okay, that's fine.
So my lady was right on both counts.
Right. Well, then can I just read through it, and then you can make your points. Right. What's the point you make?
Well, I don't need to make the point. The point is that if you continue reading this and then you continue reading below, feedback very positive from someone who's been redacted over the page. On the personal side, no matter how good someone may be, it's equally important their quality. She's one of the kindest, friendliest, etc. Incredibly helpful. Work product, very impressed. When I started working with her, relatively junior, etc. May not have understood the basics. She hadn't figured that out yet. By the time she was on my team, during my time at somewhere I don't understand, her trade ideas were honed, thoughtful, appropriate. She's relentless, but not in an annoying
Yeah. I
way.
mean, okay. We can read it. Well, what's the point you're making? That they were rating on having her?
That
And on the 11th of June.
after the bad reference in
Yeah.
May, they are continuing to solicit references and in fact obtain extremely good references and only good references until the 11th of July, which we'll come to in a moment. Next one from a redacted person working at Highbridge Capital. Very technical, go better, 90% of sales don't understand, she does. Sales wait for the phones to ring, not her. She's perseverant in a good way, thinks about client issues, etc., etc. Over the page, very technical, client focused, proactive, clearly recommend her. And then Mr. Lecoeur, who's writing to Mr. Dutree as one of the key group of people who are concerned in deciding whether they should be hiring the claimant. Spoke to two senior people at Barclays, one in sales, one in product. I both trust, I assume that means I trust both. I called them without them being aware of the other. And from the sales side, actions, equity and rates and credit, very good sales, relationship based on content, developed effective relations, very technical, pushy internally, annexed, doesn't give up, etc., etc. You can read it to the end. All in all, quite positive feedback. So that takes you, and remember, they've had now literally 5 or 6 opportunities to provide responses to DSARs in this respect, so one can assume we have a comprehensive set now. So lots and lots of really good references after the so-called bad one, until 169, and then we get the 11th of July. And indeed, even the judge records, if you go to Core Bundle 144, paragraph 44, that I took you to earlier, you will see that he writes at the bottom of the page, by email dated 5th of July, the claimant provided further positive references, but not the ones you've seen there, which are from the 11th of June, to seek to address the negative feedback that she was aware had been provided during May. It's also clear that despite the negative feedback, Mr. Dutree was actively progressing her candidacy, which was being considered against other potential candidates, and as a part of that process, on the 13th of June, she was asked to take the test. In short, ask yourselves this question. At that point in time, would it or would it not have been absurd if the process had then just stopped? Sorry, we've decided we're going to take something else. Would it have not been absurd for her to have brought a claim based on the knowledge that she had had a negative reference in May that said she was impossible, on the basis that there was some victimisation or discrimination on the part of the respondent in either taking that into account at all, letting it be significantly influential, which it appears it wasn't, and of course, most importantly, from the respondent's position as opposed to the giver of the reference, that there was anything discriminatory or in any way related to a protected act. But that's bad enough. She asks, she says, in so many words, well, just in case, can you give me the documents that will show me why you didn't take me on? And what they give her suggests a completely standard process, respondent acting properly throughout, and nothing of what happens on the 11th of July or thereafter.
Well, you haven't yet shown us what happens on the 11th of July.
So, what happens is a different second negative reference is provided, unsolicited, by Mr. Barrett, a friend of, well, we all think we assume Mr. Ferez, but he's insisted that he's not going to tell us who his Lebanese manager friend, who used to be Claimant's boss at Barclays, was. But it's someone, let's call him Mr. X. Mr. X at Barclays has spoken to his friend, Mr. Barrett, who has taken upon himself to intervene in the hiring process. And everybody...
Well, can you not show us this email?
It's the next page.
Well, I haven't read it yet.
No, my lord, I'm...
Tell us what it, then you can tell us what we get from it.
Right, my
We'll
lord.
start from the page
It's
after.
170.
We start at
170.
170.
171, my
That's
lady, is
my
again
lady's surely
wrong,
right
because
about
it's an
that.
email string going upwards. So if you go to the first hole punch on 171, my lord, you will see that Remy, who is Mr. Barrett, is writing to one of the people involved in the hiring
Can we
process.
just follow it right through? What happens is on...
So we've got the 10th that she's busy making arrangements
Yes.
with Remy to meet for coffee.
She and Remy, by the way, this is common ground, knew each other from an unrelated context. They both worked on some charity. So she knows he works at HSBC. She thinks he's friendly towards her. She gets in touch
Yeah,
with him.
no, exactly.
Then-
Well, can we not just tell me if I got this wrong? A month before all this, she writes him an email saying, "I'm applying to HSBC. I'm advanced interviews and want to have coffee with you and
Yeah.
understand things a bit better."
Correct.
And he doesn't respond to that for a month.
Correct.
Then he does respond. So I just realised I missed it. And said, "Which area are you interviewing for?" And she tells him derivative equity. And he then forwards that chain, I think he must do, to Renaud Deloy, I don't know how you pronounce him. "Is she applying to you?" And he says, "Yes, you know her.
Well,
Little, I also know her boss at Barclays. We need to talk about it." And Mr. Deloy replies back a minute later, "Interests me very much because it's not unanimous." And then he says, "We'll talk about it shortly." So I haven't. What do you say that shows?
it shows that Mr. Barrett, having discovered that she's applying,
Yeah.
takes it upon himself on the 11th of July to tell the hiring team, "I need to talk to you about her. I know her and I know her former boss at Barclays." What he said, as you will see, he took care at the time not to put in writing, but we know what he said because later documents were disclosed that show what he said. And what he said, as you've already read in the present VAT's judgment, was effectively she's brought a discrimination claim against Barclays and please don't hire her. I mean, I'm paraphrasing. And as you will also see,
Where do we see that point being just?
I'm about to take
Okay,
my
right.
route to it. But the point, remember, we're focusing. I'm not suggesting you've forgotten for a moment. We're focusing on the claimant's state of knowledge, and all we know about the claimant's state of knowledge is that, as my lord has picked up, on the 12th of June, she's writing to Mr. Barrett saying, "I'm having rather advanced interviews," so she's well on the way, she hopes, to being hired. And we also know she knows nothing of Mr. Barrett's intervention until the autumn of 2020. So my lord asks, well, what was the content of that intervention? She found out, just to be clear, in 3 stages. First, she found out there'd been an intervention with a DSAR in.
Yeah, this is the DSAR that starts
Then
the
she
process.
finds out in conversation with him on the 26th of August and more. Then she has a meeting in September with Mr. Dutree and finds out a bit more. And then she gets a further response to a DSAR request in October, where she learns a lot more. Now, obviously, much of that I can't take you to because it was in conversation. But if I take you to page 176, you will see the covering email to the 16th of October response. And that included page 177, which is from Mr. Barrett to someone at HSBC. Second paragraph, she got access to internal email exchanges in her application file. That's how she became aware, I talked to Renaud Deloy and Eric Dutree, of the negative feedback I had received about her from a friend of mine who was one of her bosses at Barclays. He talked to me about it because he knew we were alumni. I then left it to them. And then quoting the claimant at the bottom, although it's not in quotes, "I was surprised and disappointed that you reached out to the hiring manager to provide unsolicited and very negative feedback on me, coming from your friend who was a manager at Barclays without talking to me and hearing my version of the story." She then has to piece together what happens from 2 are you all working on hard copies? Yes.
Yeah.
So you can turn round to see the landscape versions of these handwritten notes at page 178 and 179. They are notes, very, very brief notes, made by an HSBC human resources employee, having spoken first, although it's the second page, to the claimant, and then, page 178, to Mr. Barrett. And the page 179, which you read, as it were, right side first, left side second, he or she is speaking to Carmen on the 21st of September, and Carmen is saying what she understands, the claimant that is saying what she understands had been said about her in this reference. Aggressive, don't work with people, cheated on the something, uncontrollable, told me, that's to say Mr. Barrett told me, that came from Barclays. Bottom of the page, interfere in the hiring process, didn't provide answer. I assume that means he didn't answer me when I asked him why. And then that he had heard on the left-hand side, discrimination claim against old boss. So of course it will be a matter of cross-examination in due course, whether Mr. Barrett passed that information on, but it's to Mr. Deloy when he spoke to him. But have a look at what he told the human resources manager at page 179. Again, these are unfortunately very, very threadbare notes. But second entry, friend who was at Barclays, then presumably the characterisation.
You mean 179?
No, I mean 178. Apologies. 178. And then again, his characterisation of what he'd been told, recollection of what he'd been told by that person, that the claimant was difficult, created problems on the desk and was creating work for him. And then a little below, presumably, she knows that I had feedback from that friend 2 years ago. Let's have a chat. She's seen that email. That's the one you saw at page 170. And then the most important words, possibly, decided not to hire at that point. And then, as if to make sure that he came across as double dealing and suspicious towards the bottom, there was a DSAR, but there's nothing in writing. Just be careful. Now, it's not often, in my experience anyway, in litigation, that one gets a smoking gun on disclosure or response to a DSAR, but this comes pretty close. Evidence that she now knows that the person who unilaterally interfered in her hiring process has been told she brought a discrimination.
So can I, just before we get all this, I mean, it's my fault, perhaps I wanted to see this material, and I've seen it. I personally, gives me a much better overview. But this is all what you discovered in 2020.
Correct.
But the real question for us is, what did she know in 2018? She clearly did not know these things because they only happened in 2020.
Well, it happened in 2018, but she found out about them in 2020.
Quite right. Okay, but this material was only generated.
Yeah.
Especially the most damaging parts. But that obviously is important to your case, that she didn't know any of that. But that's not really where the focus of the case against you is. The focus is, yes, but she already knew the substance of that, not this detail, but she knew the substance of that, and in particular, references made to the texts, you say here.
Well, references now made to the text, but
yes, I know, I got that point. But and the question is, on the basis of the material before him, what was the basis on which the judge reached his conclusion? He knew all the elements of the claim in 2018. That's really what we ought to be looking at, isn't it?
well, my lord, yes, but it has to remain a rhetorical question. All we know from the judgment of Employment Judge Berger is that he focused on the May negative
Yes,
reference.
well, I see that.
And that there is, and I mean, this, let's all be honest about this. It is extraordinary that all of this being before him, there is not a single reference to it. He says at one point she had more documents given to her in 2020, but they didn't change anything, as you've seen, which is obviously just not true. I mean, whether they changed it so significantly as to mean that she should now have time extended in her favour, you could, although I think barely argue the point, that he makes no reference to any of this evidence. And that alone, and believe me, there is more, but that alone is enough to mean that his decision has been undermined by the criteria set out by Lord Justice Leggett at paragraph 20 of Morgan. It was, and this is, again, it's so important, what claim did the claimant bring? She brought a claim against Remy Barrett as first respondent and HSBC. And to be clear, she dropped the claim against Remy Barrett on the first day of the preliminary hearing because her understanding was, and I think it's correct, reading the grounds of resistance, that the respondent was not relying on the statutory defence in respect of any vicarious liability. I'm getting helpful nods from my left, and that's Court 8 of the Employment Appeals Tribunal decision. So her claim was this guy did something unlawful for which this bank must take responsibility. Her claim in relation to sex discrimination was not Mr. Dutree or Mr. Deloy or anybody else had discriminated against me per se, but rather that she had been described in terms, you may not agree with her allegation, her allegation is that she had been described in terms that were implicitly sexually discriminatory in the documents that you've just seen that she saw in October. Yeah, she says that describing her in this way, so my lady implies scepticism, but I asked my lady, who knows probably more about this than I do, if you describe a male banker as aggressive, is that always a bad thing? If you describe a female banker,
Personally, I
it's
would
bad
say
for you,
absolutely.
of course, bad for me. Is it considered bad for the hiring manager?
In this context, he's probably a superstar.
Well, that's if you. I don't know whether you use that word deliberately. But
Well, these are very difficult areas. I mean, I had a case at the bar where one of the key issues is whether the phrase high maintenance was gender specific.
It's certainly gender connoting. Whether it's gender specific might be putting it
Look in
too
the
hard.
Urban Dictionary, the first example given is about a man. So one just doesn't know. And anyway, we're getting, it's my fault, we're getting off the point.
The point is that that's her claim. And she could only bring that claim against Mr. Barrett and what he said when she knew that he'd had anything to do with it and what he had said.
Yes, anyway.
So,
but the point is, therefore, the sex discrimination claim, we've been focusing on the victimization claim, but you say sex discrimination claim is based on the descriptions in those materials you've just shown us.
So the description of aggressive and pushy.
and if you look at
I don't doubt you for a moment, but can you just make that good by reference to the particulars of claim?
I am going to, but while we're doing, because it will save a little bit of time perhaps, if you look at the particulars of claim which begin at the start of the supplementary bundle,
Yes.
can you just see the way in which the claim is brought, and the bold headings are quite useful for this purpose. So page 2, Mr. Barrett is the first respondent, and she says she was considered the best candidate. Then she's been subjected to discrimination. Paragraph 8, Mr. Barrett was a senior manager and Barclays is responsible for them. And then the concealment point, the point that my Lady Justice Laing raised by reference to paragraph 11, the second respondent's created environment, this is in the context of the race discrimination claim, where sex, race and victimisation is practised at an institutional level. If she's complained about being discriminated in the past, and even more so where she's complained against a Lebanese origin manager, and it was put to my learned friend who gratefully accepted.
So are you diverting onto the race point?
I'm going through it because otherwise I'm going to run out of time. While we're doing the particulars of claim, I just want to point to certain paragraphs, if that's okay. It was put to my learned friend, well, is that a race claim or is that a victimisation claim? The point is, at that point, no one knows what her complaint about the Lebanese manager was. And then look at the very next heading that I'm sure my Lady Justice Laing would have gone on to draw to my learned friend's attention. HSBC victimisation, sex discrimination and race discrimination prevented from obtaining a job from July 2018. Next heading, she successfully interviewed. Next heading, they were keen to employ her. That she only found out, at least to the extent that she did find out in 2020. Then the first respondent, page 6, knew that she'd previously brought the earlier claim. Then the first respondent interfered and stopped the hiring process. And then, next page 8, the second respondent stopped the hiring process upon the derogatory discrimination, this is the direct answer to your question, my lord, and victimising feedback from the first respondent.
Paragraph are we at now?
Sorry, my lady, 44.
Thank you.
Heading between 43 and 44.
Thank you, sorry.
So my lord asked me, how do we know she was laying it at the door of what Mr. Barrett had said? The answer is that heading and the following paragraphs. And since we're here, I'll take it out of order. What about these texts that now are put before you as though they were the critical evidence?
I mean, you haven't actually answered my question.
Oh.
You're saying that the sex discrimination is specifically the derogatory comments about aggressive and so forth.
Well, it's paragraph 46, my lord.
46. So does she say these are?
Yes, she does.
Yeah, sorry, I just hadn't had a chance to read that far ahead. I told you I was slow.
Bottom of the page, my lord. The above information was unlawful discrimination.
Sex-based stereotypes. Okay, got that. Yep.
So, can I just, while I'm here, go to the texts? Now, the important point about the texts are, these are texts, all of these texts are from Hannah Assayag.
Yes.
And they are sent to the claimant. Hannah Assayag, has, as it were, sponsored the claimant.
Yes.
She's a woman in a position of management. She wants to support another woman applying. And so she appears to be somewhat alert to what could be, as she describes it in paragraph 51, biased feedback. But biased feedback would, in that context, have to refer to Mr. Ferez, or if it's not Mr. Ferez, whoever it is that provided the bad reference in May 2018. Now, maybe Mr. Ferez is biased against women, maybe he isn't. That's her opinion. But even if he is, that doesn't make HSBC biased. That doesn't make HSBC liable for sex discrimination. Paragraph 52. This is at best for the respondent a very two-edged sword. So after, as the judge has found, the hiring process had stopped, apparently Ms. Assayag talks to Mr. Dutree, and he, in her words, confesses that if she'd been a man, and this was the way you were thinking, my lady, of superstar, I think, if she'd been a man on the same feedback, she would have been categorised as a superstar. Now that is again her sort of second-hand hearsay, her understanding of his understanding of how the feedback from Mr. Farez had been interpreted, and he was frustrated. He couldn't hire her. Now, that doesn't actually emerge from the contemporaneous documents, and in fact, I suspect it isn't true. But that's what she thought at the time. But note that there is no reference to the fact that the claimant had brought a claim, let alone done a protected act, even as part of his confession of his frustration or the reasons for not taking the claimant on. Paragraph 53 doesn't advance matters, then paragraph 54. So we're now sometime after January 19. I'll read the English, not that I can't read the French, my accent's not very good though. I know why I have still faith in HSBC. I think that mainly the interviews were positive. Then the guys are afraid because they hear the feedback and because there are proceedings going on. It's a classic, or once the proceedings passes. Now, that's Ms. Assayag giving her view about proceedings she now knows, whether she knew earlier, I don't know, were going on. In relation to what she is seeing and what the claimant sees, not what the judge found, I accept, and we can't go behind that, but what she is seeing is a continuing process with a future once the process is over. What did she say? Well, yeah, but once the process passes, ... In other words, once
Well, I'm not sure. I think she's saying that the blokes are saying to her, of course, once the proceedings are over, it'll be another matter, i.e. the sort of silly thing, the sort of exculpatory thing they say.
Well, I it's not the way I read it, but I accept you could read it in that way, but certainly we don't know how it should be read. There was no evidence from Ms. Assayag.
And actually, it could be read, it just occurs to me in a way which is helpful. But that to you, it wasn't really saying we don't want to sue her because she's brought. It's a more general feeling that it's always a bad idea to hire someone who's in litigation, because that would fit in with once the proceedings are over. It's not we don't want to hire the kind of person who sues their employer, square brackets,
so
for
you think
discrimination.
calm territory as opposed, is it calm where the House of Lords, I think, found that because the reference...
I'm going deaf, Mr. Siegel, you speak up.
Sorry, I
What
think that's the territory of the House of Lords decision in, from my memory, I've got a bad memory for cases, Khan, where the Chief Inspector didn't provide a reference because there was ongoing internal or external complaints against. So it was decided that wasn't victimisation. It was just a policy that you don't provide references where there is outstanding issues of complaint. The proposition is right. The House of Lords decision, I know, is right. Whether I've got the right case name, I'm not 100% sure. But whether that's right, I mean, these are matters of nuance that had to be explored if they were going to be relied on at all, and they're not relied on, and they weren't explored by the judge.
By the judge, yes.
Or in submission by the respondent.
Yeah.
But the point is that that's her view. It's not one that at the time the claimant had any basis for accepting as valid. In fact, there didn't seem any basis for her to draw that inference from what she knew, let alone for the claimant to rely on it. And note how important this fact is. By then, she's had the response to her first DSAR. She was, you were saying, she didn't want that the judge must be taken as having decided that for so long as she was interested in a job in the future, she wouldn't be causing trouble, as it were. She's putting in DSAR with a view to potential litigation. She gets the response and looks at it and thinks, oh dear, there's nothing for me here. Or maybe not oh dear, maybe good. HSBC wasn't discriminating against me. But from the perspective
But
of
she can't thought totally good because she keeps on pressing.
Well, she presses when she finds out potentially more. But I agree that she isn't 100% sanguine about the issue. But what she does not know, by reason of the potentially accidental failure to disclose those documents, was that Mr. Barrett had intervened, let alone the content of that intervention. So in her position in January 19, never mind that if the judge is right, she's already out of time, but in her position, she's got no reason to read this text from Ms. Assayak and think, oh, I do have a claim. And as I say, of course I accept my learned friend when she tells you that she cross-examined her, but one has to assume that nothing helpful for the respondent emerged from that cross-examination. And again, although one shouldn't need to keep saying this is not even alluded to in the judgment. None of this material is
Well,
alluded to in the
as you
judgment.
say, you shouldn't need to have saying.
Well, I say I shouldn't need to, but I'm still on my feet defending a decision that is under attack.
No, I don't mean you shouldn't need to because you've made it several times
Oh,
already.
I see. Sorry, my lord. Sorry. So what we say is that on the basis of the facts found by the judge recorded in his judgment, all of them, what she knew in July 2018 is she wasn't hired by the respondent. She says she didn't even know that, but that's been found against her. And that they've been provided with a negative reference in May, but that the recruitment process had proceeded well under pace thereafter for a further 2 months. What the judgment did not find, and it couldn't have found it because the court knows now that evidence, the evidence that existed would be inconsistent with such findings, that in 2018, or indeed any time before the autumn of 2020, she knew first that the hiring managers had been really keen to hire her and had secured several excellent references, both internally and from Barclays. She didn't know any of that until she got the DSAR in 2020. Second, they were put off by doing so by information provided to them on or after the 11th of July. Remember page 178, the decision was made at that time. Barclays, or Mr. Ferrez, or whoever it was, had told Mr. Barrett that she brought discrimination claims against Barclays and Mr. Ferrez. The terms in which Mr. Barrett had described her in 2018, insofar as we know them, and they're pretty brief notes, these notes, and he may not have been telling the truth and the whole truth, she says were implicitly discriminatory. And finally, that there was an issue relating to the views of Lebanese managers in the equity derivatives team at HSBC being influenced by the fact of Mr. Farah's Lebanese origin. And note, that has got nothing to do with victimization. His original reference, if it was him or whoever it was, she's impossible. The claimant is saying she later found out on the 29th of September, we'll come to what she says, well, we have already come to some extent to paragraphs 11 and 12 to what she says in her particular claim.
So I'm not sure what point we're on now.
I'm afraid we're on the race discrimination point.
Sorry, you didn't signpost. So
I
I'm very
didn't.
glad you are. Is that I do like a bit of structure. Have we now finished, therefore, with your points on
No, I'm
discrimination?
we're almost there, my lord. I do
Why
have
not? Well, I say I didn't mean discrimination or
I know what you
rounds
meant,
1, 3, and
the
5.
time
wasn't it?
point as opposed to the.
Can we come back to the race point in a minute?
My lord, yes, I apologise. So we say that knowing that the judgment did not find or could have found any of those things, it must follow the judge gave significant weight to a factor which was, we say, just completely irrelevant, namely the, as it were, generic bad reference in May, which appeared not to have influenced matters in any way, had nothing to do with protected acts or discrimination, and even more startling, refused to take into account the most relevant, all of the most relevant factors, namely all the evidence that was obtained in 2020. And with that, we then go to paragraphs 121 and 123 of his judgment, reading them with the most benign and generous eye. Page 156 of your core bundle. So within 121, he records the claimant's case and then says he doesn't accept it. Why? The claimant's contemporaneous expressions and actions wholly undermine her contentions. So remember I said it wasn't just that he left it hanging in the air, I find against her. he actually does say something about why. What is that? What are her contemporaneous expressions and actions? He refers to them in, I'm to be slightly rude, extensive detail early in the judgment. They are the fact that she has brought claim against Barclays and made lots of DSAR requests and is generally, as it were, looking to litigate. What other? I mean, I can't answer. It's not a trick question. What other contemporaneous expressions and actions could he be referring to? Then the one that my learned friend and the court have been referring to more. The next sentence: the claimant was fully aware of of the elements of her claim due to a bad reference. I don't want to repeat myself. It's just obviously wrong. She was not aware of any of the elements of her claim by reason of the bad reference to which he is there referring. That's why I did push back at my lady's suggestion that what follows in the conclusory section, not the fact-finding section, is actually a finding of primary fact of the source of a man's digestion. It's not at all. It's bluntly sticking the boot in on the basis of the false findings he's made in the rest of that paragraph. It would be a fair inference, perhaps, if he'd been right up to there, but he wasn't. And so you can place no separate, discrete reliance on that sentence. Next paragraph, I think my lord pointed this out in argument, adds nothing. He doesn't accept the delay was relevant because the basis was apparent from an early stage and that she chose not to proceed. So that's exactly just a repetition in different words of 1, 2, 1. Then 1, 2, 3. The claimant criticises piecemeal disclosure, talks about the fact that her knowledge had been delayed and relies on Affalabi. I conclude the late disclosure didn't change what she was aware of, namely that negative references have been given. Well, I think my lord, obviously not necessarily having this precise sentence in mind when he said so, said something like, I can't remember the exact words, now that you've shown me these documents, my understanding of what happened is somewhat larger, or words to that effect. That is putting it at its lowest. To say, as he does, that the late disclosure didn't change what she was aware of in 2018 is wrong. Completely wrong. So there is not just that the judge presents you with these pronouncements and you can generously work out that he might have been relying on matters that weren't submitted to him as relevant or whatever it might be. He tells you what he's relying on. It doesn't help him. It shows that he has added 1 and 1 to make 4. That's why the judge in the AT was right to remit the question to another different judge. Affalabi, I was going to take you to. Maybe I've got 5 minutes. It's authority principally for the proposition that it will often be just and equitable to extend time. I know that was an extreme case, 9 years, but to extend time where a claimant alleging discrimination only finds out the relevant information at a time later than the act complained of. A fortiori in this case, which didn't apply in Affalabi, where the relevant information was withheld. Use the word neutrally, not deliberately, but was withheld by the respondent, because Mr. Affalabi had no idea it existed and didn't ask for it. So
I don't mind you referring to Affalabi, but are we going to get anything from it?
Well,
You only cite authority. You've already made some points illegitimately by saying this is a much stronger case than Affalabi. But
well, the first
what's the actual principle that's that?
Well, the first point I make is I think you asked my learned friend, or she volunteered, that the judge had Affalabi in mind. No,
refers to it.
It's at page para 123. You've probably still got it open. He refers to it only for a proposition that is not authority for, and not for the important proposition that it is authority for. Affalabi had nothing to do with deliberate obfuscation and misrepresentation in the context of just next extension, insofar as that's what he must be taken to mean. So that's the first point. He didn't get to grips with it. you know that it happened in that case after 9 years, another point with A40 or with the present. But it's also important to remember some of the strikingly similar facts. Mr. Afolabi discovered just before he issued that he had been assessed back in 1990, he issued in 1999, much more favourably than he realised at the time, just as the claimant did when she got all those pages between 164
I'm
and
just
169.
wondering how it's relevant to the issues in this case. If you want to take us to it, do. But I just want to know what proposition you're getting out of it. That I'm not stopping you.
No, I'm grateful. I'm simply saying that if, well, let me put it somewhat baldly. If Appelabi was rightly decided, you've got to reject this appeal.
Sorry, speak
If
up.
Affalabi was rightly decided, you
Yeah.
have to reject this appeal because all the factors that were taken into account in upholding the judge's decision to extend time in Affalabi apply here and
Well,
more
only
so.
if you're right on your other points. If she knew everything she needed to know in 2018, Affalabi is irrelevant.
Correct.
But if she didn't, then you don't need Affalabi because the judge has obviously got it proceed on a wrong basis.
Yes. All right. I'll live with that.
I
So
think you provoked me by saying I think I've got another 5 minutes, so I'll take you to Affalabi. There's no obligation to go on to 4:30, or in your case to go on to 4:15.
But you said you were going to come onto the race claim.
I will.
Yes, well, that's really where.
No, I will. The race claim for me is very simply dealt with. I know my learned friend developed it in extenso, but I don't think I need to spend nearly so long. So can I just, although I entirely agree with my lord when he said to my learned friend, what we're concerned with in this court is the employment judge's decision, really, not the AT's decision. If that decision was right, it doesn't matter what the AT thought, and if it was wrong, it doesn't matter what the AT thought. I understand.
Well, perhaps I can just say, you needn't go into this unless you want to. I am not impressed by a number of the reasons that the judge gave for criticising, but the judge in the AT gave for criticising the ET. But you would say that really doesn't matter as long as at least one of her points was good enough.
Yes, and can I just take you, I will, with that steer, take you simply to page 120 of the core bundle.
Yeah.
Within that paragraph 124, I just want to take you to D, F and G. Well, D and F in particular, but
Right.
D most of all, because I resist the validity of the criticisms of my level in relation to D. So it begins at the bottom of 120. First point, I consider the judge failed to take proper account of the fact that it was only in August, September, October, following late disclosure, that the claimant knew she'd been considered to be a very strong candidate, that Mr. Barrett had known about her previous discrimination proceedings, and that had played a part in the decision, the critical part it would seem, not to progress her candidacy. In my judgment, the judge's conclusion that the later disclosure did not change what she knew was perverse. That is 100% right. And if the best my learned friend could come up with is that instead of saying the judge failed to take any account, he said failed to take proper account, which obviously in context means any account because you read the judgment, then it's not a very good point. In the summer of 2018, she knew a negative reference had been received and provided further references to counter it. By the date of December 18, she knew Barclays had provided informal references, but not any information about Mr. Barrett's role, as revealed by the document she saw in 2020, nor that he had passed on potentially victimising information to a relevant recruiting manager. On her case, she received significant information on the 29th September about race being a factor. It's evident that the information she was provided for changed her knowledge about potential unlawful action as opposed to action taken by the respondent as opposed to by Barclays, and was directly relevant to her claims against the respondent. Further, knowledge of the refusal.
Well, you're reading all this. What's your point you're making?
My point I'm making is it is impeccable. It can't, not one comma in that critical paragraph, the most critical paragraph in the entire EAT decision, can be properly criticised. That's why I agree she gives other reasons, some of which are more or less weighty and some of which are more or less defensible. But that's the meat of it.
Okay.
And then at F, the judge did not appear to take into consideration that, contrary to his statement that the DSARs were responding to in a timely manner, significant and relevant information was missing, etc., didn't consider the manner in which the respondent had disclosed. Again, that is an impeccably made point. Respondent has got to be in a worse position if it withholds the relevant documents in response to a DSAR than if it discloses them. G, less weighty point, but doesn't really seem to have got to grips with Affalabi and what it is authority for. That, we say, is a correct summary of where the judge went wrong. So where it matters, we say the EAT judge got it spot on. I turn to the race discrimination. This, we say, is predicated on a misunderstanding of the relevant part of the judgment. And if you thought that the judgment was a little thin on the ground in relation to the reasons for the time conclusion, the ground is naked in relation to the race discrimination complaint. There is nothing in the facts or the, I think he calls it, submissions and conclusions section, that entitles you to guess at the inference which my learned friend draws from what she would have found if she had been the judge. There is nothing.
Well, you're obviously going to make that
I will.
very strong submission good. On the face of it, with the help of Ms. Sengupta's submissions, it seems to me perfectly obvious why he reached the decision which he did about the race claim, which was that it related to an act done when she was no longer an applicant.
Well, it's only perfectly obvious with respect, because that's the only way in which one could possibly defend his decision.
Well, right, so that's good enough.
No, it isn't, my lord. Not
Well,
if
suppose
he
it's
gives
obviously
absolute-
suppose it's obviously right, but is not clearly spelt out. You're not going to get a successful appeal.
That's a separate question. If you're saying to me, but Mr. Siegel, never mind whether the judge got it wrong or gave good reasons, we, the Court of Appeal, can see that that was the right decision, and therefore we're going to uphold it on the grounds we consider it ought to have been made. That I can deal with that, but that's a
Hopefully
very
we'll
different
deal
point.
with that at some point. But I also think I can't work out now what I thought when I first read the judgment, but having read it now carefully, I think the reasoning is sufficiently clear.
Well,
when you understand the structure.
well, my lord.
The important thing, surely, is whether it's a good point.
Well, my lord, I don't mean to tease or be impertinent, but at some point, if one of you could tell me which bits of the reasoning you're referring to for that proposition, I would be very grateful, because I'll take you through what I see and what is not there.
Well, look at the
This-
judgment. All acts done after or detriments complained of, to use the more, isn't it para 3 of the judgment?
Well, the judgment's at page 137 of the core bundle, my lord. There is nothing in the judgment. Look, you identified the key question. The key question is, was the claimant complaining? And it could be either one or the other or both. Was the claimant complaining about one? She found out in September 2020 that from July 2018, the judge would say only till August, from May 2018, the judge would say only to July 2018. She, at the time, was saying for much longer. She was not hired on grounds of race. Or two, was she saying, I sat in a cafe, someone made a racially loaded remark and that upset me. It could be both, I accept. But if it's one or one and two, he should not have struck out her complaint.
Yeah, well, we have to look and see what it was then, because
Correct.
the pleading's in front of us. We can see what she pleaded.
Have a look.
Okay.
It's at page 12 of the supplementary bundle. Is where my friend started, so I'll start there as well. Paragraph 81. 29th September, she had a meeting with Detreat. Detreat confirmed the reason the claimant hadn't been hired so far was the feedback received from the claimant's old boss at Barclays. That's Mr. Farres. When did Mr. Farres give his feedback? Answer, at 2 points at most, if Mr. Farres is the person who spoke to Mr. Barrett. in 2018, once in May, once in July. Not in 2020. Mr. Retreat confirmed he'd received comments from the first respondent. That's Mr. Barrett. When did Mr. Retreat receive comments from the first respondent? On the 11th of July or shortly afterwards, 2018. Additionally, comma, when speaking about the realistic possibility of the claimant and Mr. Retreat working together in the future, Mr. Retreat was worried that the equity derivatives team included a number of people from a Lebanese background which remain in direct and easy contact with Mr. Farragher, also of Lebanese origin, and this situation would make it difficult to hire the claimant in the future. During the meeting, Mr. Retreat confirmed that the bad feedback received about the claimant had emanated from one person at Barclays. The 82, on which additionally, 82, which my learned friend focuses on, is narrative. I think that was the word my lord used, in fact. It's context for learning. This is where and how she learnt about this when speaking about ... But it's obvious.
It's all narrative, isn't it? I mean,
it is. It's a particular claim written by a litigant in person.
Yeah, right.
They tend to just say, this is what happened, this is what happened, this is what happened.
right.
This is what happened. But it's obvious, we say, from paragraph 81, paragraph 83, and more importantly, paragraphs 11 and 12, what she draws from that. And I've taken you to those already. They're at page supplementary number 3. My lady, Justice Laing, took my learned friend to 11. But it's all about hiring practices. It's nothing about me sitting in a cafe being offended. And to be honest, all you need to read to know what she was pleading is set out between the two hole punches in bold and italics. I mean, please do read 11 and 12 again, but that's all you need. HSBC, victimisation and sex discrimination and race discrimination prevented from obtaining a job from July 2018. Now, unless you're going to, and I know my learned friend does in effect, cross all that out, the decision is indefensible, the judge's decision. Now, sorry, I know, well, I apprehend
And what do you say about the list of issues?
Right, so we now, that is what is effectively being said. Don't worry what she pleaded, because there's a list of issues. And I accept that if the judge had said, I have regard to paragraphs 81 to 83 and paragraphs 11 to 12, I also have regard to list of issues, you were taken to one part, I'll look at some others. And the claimant, I clarified with the claimant or with her legal representative, there was one at the time, and it was made clear that the claimant was not pursuing the claim that she had pleaded, which was that race discrimination had played any part in the hiring process in 2018, but in fact only that she'd been upset by Mr. Retreat in September 2020. If that was part of the judgment, I wouldn't have a leg to stand on. But so far is this decision, the judgment, the factual findings, and the reasoning part of it, supportive of any such inquiry, that all you have to go on is, well, that might have been what he thought. He might have effectively discounted the pleadings, relied only on paragraph 4 of the list of issues, and if he had, that might have been defensible.
He did say, I think, we can look at the exact language, but that in order to identify what the issues were, he was having regard to the list of issues. He didn't say whether or not they correspond to the pleadings, but that would hardly be surprising in circumstances where it was a lay pleading.
Well,
He says before the applications could properly,
so where are you reading?
para 5,
Yeah.
page 139, before the application could properly be determined, it's necessary to identify the relevant claims and issues. I used the claimant's second draft agreed list of issues, which set out in Schedule A. It's not uncommon, particularly where you have non-professionally drafted pleadings, for them to be, in practice, superseded by the list of issues, because that clarifies things which are ambiguous, may even, depending on how you construct the pleadings, may even contradict the pleadings. But unless there's a reason to believe there's some misunderstanding, it's right for the judge to proceed on the basis of the professionally drafted list of issues put forward by the claimant's counsel.
Well, I don't know. Can I just check one thing?
Yes.
I'll check if I may. That wasn't my
By all means
understanding that
do.
they'd
Sorry?
been drafted by council, but I will check. And I should have done over lunch. It's my fault. I meant to.
Well, no, I'm not criticising you at all. That was certainly I didn't just make that up. We clarified this morning. We were told that the date is the 4th of June.
Yes.
Sorry, council. We don't. I think, to be fair, Mr. Sengupta did not say council. I think she said legal team because she didn't know.
Sorry.
What did you say, Ms. Sengupta?
My lord, I think what I said was at the relevant date she had legal representation and legal advice, and at the date of the PH she still had legal representation, and so therefore.
I think you
whoever
also
dropped-
told us the date was the 4th of June,
Yes,
which
and-
was a week before the hearing, or less than. I can't remember what the date of the hearing.
a couple of weeks, 21st of June.
22nd of June was the
22nd.
Sorry. Okay. Whatever that is.
So it was adopted. I think the
Adopted
submission
before,
I made
yeah.
was it was adopted by the legal representatives. separately.
And was adopted.
Well, in the sense that it was the version that was being used by the solicitors and counsel representing her at the hearing.
Yes, that's what
I don't think I put it any
no,
higher
I
than
agree.
that.
Sorry, it's a red herring who drafted it. It's pretty obvious it was drafted by lawyers. I thought probably by counsel, but it doesn't really matter who drafted it. The point is, it was the one which was being advanced by the claimant's legal team at the hearing.
Well, this is a PH, and I don't know how the judge conducted it. Normally, at a PH on a time point, you find out what the respective parties' arguments are as to, for instance, on this case, what the extent of the claim is. And then, if you're not going to strike the claim out, and that's why this is only ever a draft, you case manage by going on to say, right, come on, let's all sit down and work out what the list of issues are for the full merits hearing. Now, what,
That is certainly an important thing to do, but in fact, you will also, depending what the issues are on the preliminary hearing, need to have issues identified before the preliminary hearing.
you might, my lord, but this
In
is
this case, you would, because they're time points.
well, I say it is not, at lowest, it is not good practice. More highly, it is procedurally flawed for a judge to take a draft list of issues which on its face, and we haven't even got to the list of issues yet, you've only been referred to one part of it. But let's assume
We
for
haven't
the
got
moment-
what, so I didn't hear.
I haven't taken you to the list of issues yet.
No.
But let's assume, for the sake of argument, that it's chalk and cheese.
Mhm.
You've got pleaded case, race was part of why I wasn't hired.
Mhm.
List of issues, race was offensive to me on the 29th of September. Let's assume that for the
Yeah.
moment. As a judge, what he ought to have done is to be very clear, which of these am I going to be
If
adjudicating?
any ambiguity or conflict, he should have clarified.
And at the very least, when he comes to deal with the race discrimination claim, which he never in fact does in terms, he should have said, even if he hadn't done that process of clarifying it, he should have said, I am dismissing this because I am taking point 1 in the list of issues to supersede paragraphs 11, 12, etc. in the pleaded case. Can we now quickly look at what he says?
Yes,
So can I ask you to go to 161 in the core bundle?
yes.
Read to yourselves under the second hole punch 2.3.26.
26. Yeah.
I'm so sorry, it's my fault, I'm slightly behind.
161 of the core bundle, my lady.
161, sorry.
Third paragraph from the bottom.
Can we just see the heading this is under? These are 26 or rather more points, which are all headed by 2, 3.
Victimisation is the heading.
Yes, detriments. I've headed it. Subject them to the following detriments.
The point I'm making is, if this was drafted by council, and if council had meant to, as it were, abandon any link between the fact that Mr. Farrows was Lebanese, the fact that managers at the respondent were Lebanese, and the fact that managers at the respondent are Lebanese, were apparently saying because Mr. Farrows was hostile to the claimant, regardless of any protected act, by the way, that's the race claim, they were not happy for her to be hired. If that link was to be abandoned, would you read 2.3.26 in that way? Sorry, would you write 2.3.26 in that way? So that paragraph 4, which is on the following page under the heading Direct Rates Discrimination, is shouldering an awful lot of weight when you contrast it with paragraphs 11, 12, 81 to 83 of the particulars of claim, and paragraph 2.3.26 of the draft list of issues. And I repeat again though, had he said in the judgment, yes, it should shoulder that weight, that's what I decided this claim on. I decided it purely on the basis of what was said at paragraph 4, but he doesn't. Can we now see what he does actually say?
Can I just ask this question before you do say that? What is being remitted? Will this issue also be
Yeah.
remitted? Yeah. Okay.
That's what the AT judge simply says. I mean, she comes under some sustained fire from the respondent, but all she says on this point is, we have absolutely no idea why the judge dismissed this complaint. Did he dismiss it for the reason
I've got the point.
Yeah.
I've only got a few more minutes. Were you about to show us something else?
Yeah. So, well, I want to take you to the judgment now.
Yeah. Okay.
So, first of all, judgment itself, which starts on page 137.
Yeah.
You will not find the word race in the 6 paragraphs of that judgment, or any implicit reference to the race claim or what happened on the 29th of September. So the judgment tells us nothing. That's
I don't think, am I right in saying the judgment doesn't talk about race, sex or victimisation, does it?
I agree. I'm simply saying there is nothing in the judgment that tells you how the judge analysed the race claim. I don't think that's controversial. I'll put it another way, my lord. Is the judgment consistent with paragraphs 11 and 12 of her pleaded case? The answer is yes, it is, because the judge found that in respect of her complaint that there had been victimisation, sex discrimination, and race discrimination in the failure to hire her in 2018, she was out of time, obviously uncontroversial, and time shouldn't be extended for any of that, because she knew what she needed to know in July of 2018. That's a perfectly fair reading of the judgment. So then we turn to the facts. '73, I believe, is the only reference, paragraph 73 on page 148. Mr. Detreat met the claimant. She covertly recorded the meeting. He's alleged to have made a comment about Lebanese connections, which forms the basis of the claimant's race discrimination complaint. On either reading, that's 100% true. If you read paragraph 11 and 12 of the particulars of claim, his remarks are the basis of that race discrimination complaint. If you read paragraph 4 of the list
Got
of
the point,
issues,
yeah.
yeah, okay. That's it. Don't look for anything else in the facts. Then go to the discussion bit, the bit that's headed submissions and conclusions on 153. This is very quick. There's nothing. Absolutely nothing. Now, as an appellant,
but that all depends, doesn't it? If it had to be, if there was a time point about the race claim, it had to be considered. If there wasn't, it didn't have to be considered. The Semgupta says there wasn't because it was all about something that was in time anyway. And you say, no, it was about more. So in a sense, this isn't a separate point about how obviously the tribunal didn't deal with it under this point because of, and the question is, was it, sorry, I'm expressing myself badly. This all comes back to the point you've already addressed us on. What was the nature of the claim?
Yes, but all I'm saying is that there is nothing in this document that tells us whether there are two options. He either, assuming it is an either-or situation, as I say, it could in theory be both. But in respect of the I was offended in September 2020, he could have struck that out on the basis she was an applicant at the time.
Yeah,
On the basis that it was
which he
part
did,
of
which
the-
on Mrs. Sengrupta's analysis, he did. See paragraph 3 of the judgment, which is just general about everything done after that date.
Paragraph 3 of the judgment as a whole is consistent with both. If he was dismissing the complaint because a complaint made at paragraphs 11 and 12 of the Pleadings of Claim, he dismissed it because she knew all she needed to know. She was out of time and there was no reason to extend. If it was limited to 29th September 2020, he dismissed it because it was 29th September 2020, and after, therefore, July 2018, and everything after July 2018 is out.
But I suppose what I'm putting to you is simply how we should approach this. I put the same point to you a few minutes ago. If we are with you that the pleading means what you say it means and is not superseded by the list of issues, then obviously it needs to be dealt with and has to go back. If we are not with you, then, and we are with Ms. Sengrupta, then even though the judge may not have been explicit about his reasoning, either you can say it's nevertheless clear what his reasoning was, or whether it's clear or not, it was obviously right. So either way, you it all turns on the construction of the pleading of the list of issues, doesn't it?
Well, my lord gave a sort of escalation of potential outcomes. So first, if you go by the pleaded case, it gets remitted, but it only gets remitted on the same basis as the sex and victimisation claims get remitted. So if you're against me on all of that, and she knew everything she needed to know in 2018, then nothing gets remitted on that.
All right, but I mean, assuming you won on that.
Right. Second question, what happens, you said, if we believe that the judge's reasoning in some way can be shown to have proceeded along the lines Mr. Sengrupta suggests? The answer to that is you can't find that. There is nothing in the judgment that allows you to find that.
But so I don't know whether I'm being, it's this stage of the afternoon. If we decide that Ms. Sengrupta is right, that whatever the pleading means, which it may be ambiguous or there may be argument about, the list of issues is clear that this is a complaint only about an event in September 2020, at which time she was not an applicant, then we should not allow the appeal, whether or not the judge should have dealt with it properly.
Well, I was about to come to that with your third point, which was never mind what the judge did and why he did it. You, the Court of Appeal, can see that the only sensible outcome is to dismiss the race discrimination complaint. And I said, I mean, in a sense, I've dealt with it implicitly already, but I deal with it explicitly now. We say you can't say...
No, I've understood that to be your submission.
But because of this conflict, if there had been no paragraph 11 and 12, 81, 82, 83, then I understand. But because of the conflict, as a judge, I don't know if any of you have sat as employment law judges, but certainly as a first instance judge in that situation, would it hypothetically be acceptable not to make any such inquiry, but simply to say, well, we've got this draft list of issues, we've got a lawyer in the room, he's not said that it's not complete, we're not going to ask him about this or any conflict with the particulars of claim, we'll just go with paragraph 4, and if 2.3.26 doesn't seem to be consistent, well, that's under victimisation. Is that an acceptable way forward? If it is, you're entitled to substitute your view as effectively...
Right, well, I think you've answered my question.
Yeah.
Well, it's 4:18. Thank you very
Sorry,
much indeed, Mr. Siegel.
I've just taken instructions on that point. The claimant who is in France looking after a young baby wants.
Can you speak up a bit?
Sorry, the claimant who is in France looking after a young child wants me to make sure that you do not understand the position to have been that she was, as it were, continuously making DSAR requests and claims. There was a process in 2018 which then restarted in 2020 after the responses.
We have some
to the
findings, don't we, as to the dates of the D-Star requests?
DSAR. It wasn't, as it were, a continuous. Yes, they are set out in 142.
Well, speaking for myself, I don't make any assumptions other than what appears there. But you're right, there was a gap in 2019 and early 2020.
Yeah, my client is following on a live stream and obviously
No, I may have said
misheard
something. I may have said something, in which case I apologise, which gave the impression that I thought that there were further D-Star requests between 2019 and 2020. I do not understand that to be the case.
That's just on his. Thank you very much for indulging.
My lord, my ladies, I was going to just use the short time available to show you some particular documents and references in relation to the just and equitable side of the appeal. I wasn't proposing to go back over the pleadings in respect to the discrimination.
No, I mean, replies for replies, so, yeah.
May I just pick up briefly in the supplemental bundle at page 3. I've made reference earlier to the claimant having been made redundant at the immediate return of her maternity leave after her first child.
Yes.
That is seen at paragraph 12 of the particulars of claim. May I take...
What do we get from that relevant to any of the issues?
I'd mentioned it before, my lord, in relation to, and so I just
I see, okay.
mention that.
Yep.
In the tribunal's judgment, may I invite you to turn up paragraph 27. Core bundle page 142. This is the extract that you've looked at from the claimant's Barclays witness statement. My learned friend was describing some of the feedback that he said came to light and that he says has sexist connotations, and if I can put it that way. And we've heard about the reference to total disaster, certainly read about it. This is a reference that the claimant made in her witness statement in December 2018. In the middle of that paragraph, I've been told by Eric Dutoit that in breach of policy, unofficial feedback was provided to new employers stating that I am a total disaster.
Mr. Siegel did take us to this very passage, but what's your point?
My lord, this feedback obviously predated, and this description with its potential sexist connotations predated the feedback that the claimant says later came to attention in 2020. And we say this assists in the tribunal's findings that what she became aware of in 2020 was consistent with what the information that she had.
So what's sexist about saying someone's a total disaster?
Well, in the same way that the other remarks that the claimant relies on as having sexist connotations, we say that this also.
Well, I must say I find that a bit anyway. I find that a bit hard to follow. You can argue about whether saying that a woman is pushy or aggressive is a sex stereotype. I don't think I've ever heard it saying someone's a total disaster is a sex stereotype. It's completely sex neutral. Yeah.
And whilst we're in the tribunal judgment, may I take your lordship and ladyships to paragraph 108 at page core bundle 154.
Yes.
Just to draw attention to this reference, which is in the section 39 section of the judgment,
Yes.
but at the bottom of paragraph 108,
Yes.
the judge refers to the loose, out of context, unguarded conversations from the respondents. And those are references to the covertly recorded conversations by the claimant with Mr. Barrett on the 29th of August, we say, and the conversation with Mr. Dutoit that she covertly recorded. So I just wanted to draw that to your attention to provide context in terms of the conversations relied on by the claimant as having happened in 2020. Those were the tidy up points I wanted
Thank
to
you very much.
take the court to. But in relation to the documents that the court was taken to in the supplemental bundle that were provided to the claimant late as part of the DSAR responses, may I just take the court to page 170 in the supplemental bundle?
Yes.
And as I take the court to these documents, I draw analogy to the approach taken in Jones that you looked at over the adjournment, where even though the claimant in that case said, well, I didn't know enough, I didn't know the race of the successful candidate, but nonetheless put in a race claim, that we're in similar territory here. Because when one looks at the documents that came through late, they don't, I submit, establish or show that that Mr. Barrett knew in 2018 of the claimant's Equality Act claim. If one looks at SB 170, it says, Mr. Barrett says, we need to talk about it. I know her a little. I also know her former boss at Barclays.
Yes.
So the new information is he knew the former boss,
Well,
and also that he spoke to
I don't want to
Deloitte.
cut you short, but in view of the time, I don't think Mr. Siegel relied on that. That was all part of a sequence of events leading ultimately to the two manuscript notes, which do refer to the fact of discrimination proceedings having been brought.
Well, my lord, I was coming to that.
Oh, I see, right.
And if we look at that, so
Page 179.
yes, my lord, page 179, as Ms. Siegel correctly described, are the handwritten notes by HR of a meeting with the claimant as part of the HR investigation, and the date of that meeting is the 21st of September 2020. So she knows what she said to the HR individual on the 21st of September 2020. And what she said, what the claimant said to HR, starts on the right-hand page, right-hand side of that page.
Yes, I see.
And then on the left-hand side, that reference to discrimination claim against old boss.
I've got your point. Your point is that she obviously knew she brought a discrimination claim, but this wasn't. The only relevant page for showing what Remy knew is 178, which doesn't contain any reference to discrimination claim. Is that the point?
My lord, yes, and this, of course, is exactly that.
Your point, therefore, is as in Jones, was all very well to say you didn't know, but you didn't know when you brought this claim.
My lord, precisely the point. So those are the points that I make on the documents,
Yes, thank you.
and the claimant has not been able to point to any document, I submit, that was the smoking gun that says he knew,
Yeah.
etc. The final document I wanted to take the court to is in the supplemental bundle at page 180. And I'd invite the court to read this later. But for now, this is an extract from the claimant's...
Sorry, which page do you say?
I'm sorry, my lord. Supplemental bundle, page 180.
Yes.
This is an extract from the claimant's witness statement in this litigation for the preliminary hearing. This is the section on time points, continuing act, just and equitable extension. And when one reads that statement, one can readily see the way in which the claimant was putting it before the Employment Tribunal, including in particular, at the top of 182, subparagraph 5 of 151, she said, I was reluctant and at times scared to sue HSBC in terms of the likely adverse impact on my career. And that provides the context. It wasn't even in cross-examination, it was her own witness statement. That provides the context for the tribunal judge's finding. She preferred not to sue HSBC. That is one of the important passages in that witness statement. I invite you to have regard to that when one looks at, it's the basis or a basis. for-
Yes, what you
fi-
say is that statement in 121, there was debate about whether the final sentence saying
Strategically opted.
strategic
Yes.
was simply a comment on or said to follow from the previous sentence, and this counters that suggestion.
Yes, and it's
You would say negates that suggestion. but certainly-
and Lord, for your reference, it's paragraph 121, the
Yes,
strategically
quite.
opted. So unless I can be of any further assistance, those are my submissions.
No, thank you both for very cogent submissions, and also to those behind you who obviously have helped you get to the position where you could make those very cogent submissions.
Thank you.
We will obviously be reserving our judgment. We will, in preparing it, look at the written submissions. As I've said, we will ask for submissions only if they are of material significance or potentially decisive significance in our decision making.
My lord, so we should wait to hear from you.
Yeah, well, you'll send them without
We will.
waiting, yes.
I'll liaise with them
And
then
you
from-
will either then get a draft judgment, or you may, before you get a draft judgment, saying we're concerned about point X or Y, and can we have
Thank you.
submissions? Right.
Thank you.
When you eventually get the draft judgment with two experienced counsel like yourselves, and at 4:32 in the afternoon, I'm not ready to go through the whole speech about the importance of using the draft judgment and disclosing the draft judgment only for the purposes for which it is being sent. But you will be aware that if you ignore those guidelines, there's a potential for contempt of court. And if you're in any doubt, read the Counsel General for Wales case. Thank you.
Thank you.
All rise, please.